Hello, I'm here today with housing barrister Peter Marcus, and Peter's going to tell us a bit about his work as a barrister. But Peter, first, what attracted you to the law initially, and what did you do first?
Well, I've always worked in housing. I started off as a campaigner on a pretty gruesome council estate in Manchester.
What were you campaigning about?
Housing. It was a disastrous 1960s council estate, but one of the biggest in Europe. And it had all the problems you'd expect, from crime, prostitution, drugs, to bad buildings, asbestos, cockroaches, and lots of other things besides. And there were a lot of tenants in need of help, and frankly there was a council in need of help too, and a government that curiously wanted to help. So that took up about the first 7 or 8 years of my adult existence, and then I went to earn some money by working for Camden Council in London as a housing, what was I? I was sort of all-purpose housing manager. And then I got a job for the Joseph Rowntree Foundation, so I had a national remit to commission research about housing, regeneration, and I got to a stage where I thought I could either stay in this for the rest of my life or learn a bit about law. So I decided to do the latter. I gave up my reasonably good job and went to law college, and quickly realised that that is actually what I wanted to do, but only about housing. So everything I do now is law relating to property that people live in, whether for the landlord or the tenant, or sometimes both, for local authorities, housing associations, or private sector.
So what sort of cases do you have? What are they sort of about? Like they're mostly disrepair or unlawful eviction? What sort of topics do you find that you're...
A bit of a mixed bag. I mean, barristers do basically 3 things. We advise. So we're like the consultants to the GPs. The solicitors get people through the door constantly, loads of cases, but when something comes up that's too time consuming for them to do, because they've got more clients waiting in the waiting room, they send it off to a barrister for some advice, because it's a bit specialist. Secondly, we'll do pleading. So when a case does go to court, we'll write the formal legal documents. And then thirdly, I think the bit everyone knows, we do the court cases when they come to court. And that kind of mixture suits me quite well, and housing's quite a nice subject to do that in, because it's got a mixture of quite crunchy legal academic things, but it's also about fighting stuff in court. And the things that go to court, so the things I advise on, for local authorities and housing associations, a lot of the time it's about possession. So possession for secure and assured tenants, against secure and assured tenants, on the basis of antisocial behaviour, particularly drugs, particularly crime. With the new Antisocial Behaviour Act, there's all sorts of different ways now that public landlords can evict tenants, but also that tenants can defend that. Although I tend to be more instructed by landlords than tenants. There's a huge wave of disrepair claims that's now sweeping the north, and I have to say, cards on the table, I only represent public landlords in that respect. And then unlawful eviction claims, I tend only to represent tenants, but once in a while a landlord will ask for a bit of advice on that. Otherwise interesting, I mean, I'm doing quite a long drawn out case at the moment about a public landlord that's claiming the tenants of the property aren't really the tenants of the property. They're not living there as their only or principal home, and that takes quite a bit of proving in court, quite crunchy facts. So it's quite varied.
Can you tell us about some of your particularly exciting and successful cases?
My memorable moments? Well,
yes.
Endlessly is the answer, yes, of course. I mean, a couple of years ago, I suppose a highlight was a case I had in the Court of Appeal, which I lost for my social
Surely
landlord.
not.
No, hard as though it is to believe. I still find it hard to believe, actually, but there you go, I did. And it was a case where a tenant had been using her 3rd bedroom of her rented housing association accommodation, not for her new baby, but for 76 cannabis plants.
Oh, yes.
And her partner took the rap for it, and she was I think she avoided criminal prosecution, but it was still obviously a very serious breach of tenancy. But in assured and secure tenancies, as opposed to assured shortholds, you can beg for mercy and ask for the court's extended discretion to suspend a possession order on the basis of not doing it again or behaving yourself. And it was a question of whether that should have been exercised by the court or not. The Court of Appeal said it should. I still think it shouldn't. I've got a similar case, actually, hopefully won't go to the Court of Appeal, because my clients hope it doesn't, because it will cost too much. But again, it's about drug dealing, it's about Greater Manchester, it's about how you should judge, if you're a judge, whether to give a tenant a further last chance or not. And that one's at a much earlier stage, so it hasn't been decided yet.
Peter, you've been talking about cases which social landlords have to deal with. There are a lot of cost implications, and that you know, they're sometimes a bit strapped for cash. What is the effect on them of having to deal with litigation? Does it have a negative effect? And
well, public landlords are no different from any other landlords or any other people. They don't like spending money, and they haven't got a lot of it to spend anyway. And it's particularly expensive now to go to court, particularly if you're appealing and appealing again. Court of Appeal is incredibly expensive simply because of all the time that lawyers have to put into preparing a case like that. So my main instruction is usually to try and avoid that sort of eventuality, whoever I'm being instructed by. So quite an important part of my practice now is making sure that if I can, well, not only that I can win the case for my client, but also, if I possibly can, get their costs paid by someone else, whether it's the other side or if they've been sued by a legally aided party, whether it's the Lord Chancellor, because that is possible. A lot of people don't know that if you're an individual, even at a trial of first instance, you get sued by a tenant and you win, you are entitled to claim your costs back even though they were legally aided. So that's a bit of a speciality of mine as well, and puts a smile back on some people's faces, because if you win a case but you're still thousands of pounds out of pocket, it doesn't feel much like winning. What about, I mean, settling as well, I suppose, is a I do a fair bit of I mean, obviously you have to negotiate, it's only fair. If you can avoid unnecessary litigation, you always should. So again, part of my activity is working with a solicitor or just an individual and working out how to put a settlement to the other side which might bring something to a sensible conclusion before it goes any further. And if it doesn't work, then it looks good at court if you can say to the judge, after you've won, we could have avoided all this because we put a sensible offer in 6 months ago. So
and that'll improve your costs award as well.
Improves everything. It makes everyone a lot, well, makes my people a lot happier. I've got an interesting one on private sector tenancies. The need, obviously, to have served an energy performance certificate on a tenant before a landlord can rely on a Section 21 notice. I'm representing a public landlord again, but it is a Section 21, an assured shorthold. And the property that's demised or let to the tenant is not a self-contained flat. And in those circumstances, I shall be arguing in the appeal court that you don't need an energy performance certificate at all. Not for the whole building, not for part of it. It's just not appropriate. Of course, those who argue for the tenant are saying it is. So we'll get a decision on that quite soon. That'll be interesting, because I think it'll be an important decision for people. It should be. I mean, if you can serve an energy performance certificate, do it. But the question is here, can you actually do it at all if the property is not self-contained? We say you can't. We'll find out, in fact, quite soon whether you can or not. Okay, so watch out for that one, folks. So do you do any other? Do you do any training or any writing? What other things do you do as your part of your barrister work? Well, it's not really part of barrister work. It's sort of what I do in addition. And I love training, I love teaching things, because I think it's a good way for me to learn by going over and over it again and making other people understand. If they've got blank looks, it probably means I haven't understood it well enough to convey the message. So I do quite a lot of training, and not as much writing as I should do. We're always being encouraged to write more articles, and if I got the time I would. But,
yeah, it is a time-consuming thing.
It is.
Yeah. Yeah. Okay, well, thank you very much, Peter, for coming in and talking about your barrister life.
Always a pleasure.
Okay, thank you.